1 through 6, the homicide counts.
Okay, we're live
61
on
through
YouTube as well.
I believe 60.
It would be 7 through
67 have that special verdict, and then the hit and run counts have the special question related to did each of the counts involve the death of a person, and it names the person alleged to have been killed. So those look to be all in order. I've already addressed going back to the jury instructions 315. We have done a little bit of rearranging some of the order, but the content is there. It is my practice to read through all of the instructions up until the point of closing arguments, and then I stop. Parties are given their opportunity to argue the case to the jury, and then following that, there are what I like to call the closing instructions, or which are still quite lengthy in this case, given that they go through the verdict forms specifically. And then, of course, the alternate jurors would be selected. But given...
Am I muted?
No, you're not. You haven't been.
So I got a question about the hazard for use of a dangerous weapon. How is that being charged? Is that under 939.632?
It is in the charging document, sir.
How is that being charged? From my understanding, that the statute reads the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. Without the vehicle, there is no crime. So that would apply. So how am I charged with?
State one is your argument only as it relates to counts 1 through 6 or others?
Whichever count has the enhancement penalty for use of a dangerous weapon.
Well, that would be all of the intentional homicide charges and all of the first degree recklessly endangering safety charges, so counts 1 through 67.
So 1 through 67.
Correct. I can have the state respond to that.
Yeah, how is the alleged defendant being charged?
So are you asking how, or are you making a specific request?
Wisconsin is one of the... I'm going to mute this. Wisconsin is one of the 12 states that does not currently have the death penalty for murder and other serious crimes like that. So, no, he's not looking at the death penalty.
That's why there's the question. Reading the statute.
And which part of this? I'm sorry. Which part of the statute are you referring to again?
I believe it's 939.632.
And your specific argument is what again?
How is that enhancement? How is the alleged defendant charged with that enhancement when reading the statute it says it? Well, I just read it, so.
I believe you're referring to sub 2, which states the increased penalty provided in this section does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge.
Right, that's what I just read.
Well, what's the state's response?
Using, possessing, or threatening to use a dangerous weapon is not an essential element of either first-degree intentional homicide or first-degree recklessly endangering safety. If it were, it would be one of the elements in the standard jury instructions, and the defendant can see it is not. This is different from a situation like armed robbery, which does require the use or threatened use of a dangerous weapon. So the penalty enhancer is correctly charge for those two types of crimes.
Any final argument on that, sir?
Yes, that's not what the statute is clearly saying. It's clearly stated it does not apply if possessing, using, or threatening to use a dangerous weapon is an essential element of the crime charge. If there's no vehicle involved, where is the crime? It has to be an essential part of it to even be a crime. The alleged defendant is charged with using a vehicle to commit these crimes. If there's no vehicle, where's the crime? So it has to be an essential element of the crime.
Is he
Otherwise,
serious?
there's no crime.
Are you
I think
arguing that it's
the
not an essential element? Like, I need to know.
If you read in the statute, it's the essential element. You can't just walk up to someone and quote unquote run them over. There has to be something used in order for this alleged crime to transpire. And
You used the vehicle.
essentially mean the quote unquote dangerous weapon. So without the
I can't.
quote
Y'all.
unquote dangerous weapon, where's the crime? So how can it be charged when it is the essential element of the crime charge?
Well, sir, I've listened to your argument. I've read the statute. I've looked at the elements for intentional homicide and first degree recklessly endangering safety. Neither one of those crimes have as an element in it use of a vehicle. There are certainly many different ways that both of those statutes can be violated. While it's true that in this particular case, the use of the vehicle is the mechanism or instrumentality that's being alleged to have been used, but it's not the same as being an essential element of the crime. I think the armed robbery crime is a good example of when you could not face an enhancer for use of a dangerous weapon because you can't have the crime of armed robbery without the threat or use of a dangerous weapon.
If you're currently watching live on TikTok with us, you can head over to YouTube and ask questions in the comment section if that's something you want to do.
It's not an essential element of either first degree intentional homicide or first degree recklessly endangering safety. So I'll deny the request to strike the enhancer for those reasons and find that it is properly before the jury for their determination.
She absolutely should say, your lack of understanding is not my
Understood. Do
fucking
you have any
problem.
other
Should have kept a public defender.
Challenges to the verdicts you'd like to raise at this time?
Yeah, would that be my objection to that?
Yes, that's what he's trying to
It
say,
is.
which is insane.
Can I request a legal reconsideration of your ruling, Your Honor?
Denied.
May I request a written finding of fact for your ruling, Your Honor?
Denied.
Oh God, I can't.
Just for the record, it's my understanding that the verdict forms were put in the garbage by Mr. Brooks and they remain in there. That was provided to me by the bailiffs.
May I respectfully request a written judicial finding of facts and conclusion of law for this issue, Your Honor?
You may request it. The request is denied.
For the record, may I respectfully move for interlocutory declaratory appeal on this matter?
This is not the proper court to grant such relief.
For the record, may I move to stay these proceedings until this instant matter is adjudicated by a court of competent jurisdiction
Your request is denied.
based on what law and facts?
Your request is not based in law or facts.
This is so ridiculous.
I just read a statute that it came from. My argument was based on a statute, on Wisconsin statute.
That's not how that works, my friend.
Your objection to the court's finding and determination is noted. I decline to issue any type of written decision or stay pending appeal. Noting there is no appeal that has been filed.
Now let the record show that this court will not allow the accused to adequately defend themselves in this matter.
The court's already made its findings regarding the forfeiture of right to testify and the forfeiture of the right to present additional evidence and
Which
testimony.
was not,
I'm not gonna
which was not
revisit the same.
which was not consented to. I never stated that I did or did not want to
Understand,
testify.
I understand.
So how can that decision be made on my behalf when I didn't say either way? What I stated was I didn't understand the questions being answered.
Sir, do you have any other questions or issues regarding the verdict forms?
Your Honor, are you making a judicial determination that you don't have to answer any questions?
I'm not answering those questions, sir, other than how I've already answered them.
Is that a judicial determination?
Sir, every decision I make is a determination by this court.
She's the
Is it a
judge.
judicial determination?
Yeah, she's the judge.
Sir, I will ask you once more.
She's
Do
in
you have any other
charge.
issues?
And I will
To
tell
raise
you once more, I
with-
don't understand the questions that you are asking.
Sir, do you have
That's-
any other issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
That's nobody's
Don't
problem.
please Not answer the question. I'll ask one last time and specifically advise.
Your
that
lack of
failure to
understanding-
answer the question will be taken by this court as.
It has no bearings
Sir,
on
do you
what's
have
going on.
any
Under what law of
additional,
fact? Under what law of fact can you say no? when I'm
sir, do
telling
you
I
have
don't
any
understand?
additional issues to raise with respect to the verdict forms?
I do not understand the questions that you are asking.
All right, he
I
has
don't
chosen
understand.
not to answer other than by saying he does not understand the questions. He did not specifically answer with a yes or no. Therefore, this court takes that as he does not have any additional issues
That
to
is-
raise with
That
respect
is incorrect.
to the
That is
verdict forms.
incorrect. That is incorrect. I stated I don't understand. You can't force me to understand something, Your Honor.
Right, did the state have any
It is-
other,
It is my
I'm gonna mute him
constitutional right.
momentarily.
It's
Mr.
my
Brooks, I'm muting you
constitutional
because
right.
I'm moving on to another topic. I understand you disagree.
Like this
with the
poor
court's
court
rulings,
reporter,
but
y'all.
You need to respect
The
the
court
rulings with
reporter.
proper etiquette in this courtroom.
Bless
Which
her.
you're demonstrating once again, you're not willing to follow, so I exercised my ability to press mute. Does the state have any other requests as it relates to the jury instructions? I wanna kind of full circle back to that because I do need to approve of them.
We do not.
All right, Mr. Brooks, I'll ask you the same question. I will unmute. Do you have any additional requests as it relates to the jury instructions?
Yeah, I have questions related to all of them because I don't understand any of this.
My question was not, do you have questions, but do
And
you
my
have any
answer
requests?
was, I don't understand. And I've made several requests.
The requests are not related to the jury instructions, which is the phase of this hearing that this court is attempting to conduct with you and give you the opportunity to fully participate. Mr. Brooks is choosing not to answer
Everyone
my
watching
question.
is fighting for
I'm
their
gonna
sanity.
Mute him momentarily, sir. I will ask you one more time if you have any requests as it relates to the jury instructions. I then will ask you if you approve of the jury instructions. If you do not answer those questions as it relates to the question, do you have any requests as it relates to jury instructions? I will interpret that as a no. And if you do not specifically answer the question about the jury instructions, I will interpret that as your approval. So first question to you is, do you have any, and you're unmuted, do you have any requests at this point as it relates to the jury instructions?
And I just said before, I said I do. I said I don't understand the questions. Of course I have questions if I don't understand.
So do you have any
That's common
requests
sense.
for any additional instructions that are
Yeah,
not included, or to remove any that are included?
Yeah, remove them all until I understand, or add the jury instructions that I have myself.
What jury instructions do you have, sir?
So now you don't know I had jury instructions and I told you this weeks ago.
Oh my God.
What filing are you referring to, sir? If I've overlooked that, I will certainly reconsider, but I'm not
You
aware of a
overlook them.
specific jury instruction.
It seems like you overlook a lot, Your Honor.
What'd she
Point me
overlook?
to a specific filing?
So you have all my filings on file?
No shit.
Are you saying that you have my filings and they haven't been admitted into the evidence?
Oh my computer's not working.
Oh, now the computer's not working.
If you filed it with the court, it is a
Sir,
public
please
record.
direct me to the specific filing that you're referring to that has a request related to jury instructions.
You just said you was referring to the filings, right? Did you just say that?
That's not what I said.
Didn't you just say what filings are referring to jury instructions? Did you or did you not just say that?
I said, do you have a specific filing you can refer the court to that relates to jury instructions?
So is your computer working or is it not working?
It's being a little temperamental, but I just can't use my search function. So if you can direct me to a filing, that would be great.
Listen, this guy's convicted himself at this point. Let's just cut the shit.
Sir, simply filing something with the court does not make it evidence during the evidentiary phase of the trial. There are rules of procedure, rules of evidence that govern that.
And you told me to make all my filings in writing.
So I said if you had a motion, it needed to be put in
All those
writing.
were motions. All those were motions.
So
Oh my
what
God.
filing are you referring the court to?
We'll do all my motions.
So it's not my job to advocate on your behalf. If you have something in particular,
I asked you to do your job.
sir, if you have something, a specific request, now is the time to make it.
Well, how about this? I don't accept none of those jury instructions. I don't accept any of them. Any of them. And again,
She was trying to help you with the jury instructions, you fucking moron.
Why do I have to keep saying this when it's clear that I don't understand?
That's nobody's fault but your own.
Inform the court that jury instructions were due, I believe, on August 30th. The state submitted their proposed jury instructions as well as the substantive instructions, and the defense indicated that they agreed with our filing. So I don't believe that there's ever been a request for any different jury instructions than what have been filed with the court.
So which jury instructions are you referring to, or what document is being referred to on the alleged defendant's behalf? Because as
You
all
should
know,
have
I didn't
submitted
obtain the
this shit.
the discovery in full until the end of September. So there was documents that I didn't even know that existed.
Mr. Brooks, one final time, do you have any specific requests as it relates to the jury instructions other than your request that they all be struck?
And I'm telling you, Your Honor, I don't understand the question. I can't.
All right, then I will take his response that he does not understand, that he does not have any additional requests,
I didn't say
and
that.
they will
I
be
said I don't
approved.
understand.
They will be
You
approved
can't.
and are,
No,
I'm gonna have to mute
No.
him. They are approved as been drafted by the court and modified during the jury instruction conference on the record this morning and this afternoon. I will once again review all of them just for grammar, just to make sure all of that is correct. And provide a written printout of the final draft for the parties before we break for the day today. I am also approving of the verdict forms that have been previously submitted to the parties, just noting there's just a few grammatical things that need to be corrected, but the content and substance are there, and I've already addressed on the record any requests by the parties this afternoon.
No, Your Honor, I believe that the final copy that we've been working off of is appropriate.
Any comment about that, Mr. Brooks, or any statement?
I don't consider being called that name, and I've just told you, I don't understand these jury questions. I'm not going to know how they allow it to pass just because you feel that they should. when I'm telling you I don't understand it.
I would know, but
Not one of those jury instructions came from me, not one. How's that fair?
That's your fucking problem.
Mr. Brooks, this court
What do you mean?
gave you the draft of the jury instructions. I need to mute you because once again, he's debating about things that I think are very clear on the record. This court provided both the state and Mr. Brooks with a written printout, 107 pages long, of the jury instructions it was considering in this case. We had a discussion this morning. We continued that discussion this afternoon. Prior to breaking for the lunch hour, all of the verdict forms were printed off and provided to both the state and to Mr. Brooks. It is also true that when he was previously represented by counsel, the court had some specific deadlines related to jury instruction proposals.
Notice he's
And,
not even, he doesn't even have the
reminded me
headphones
that
on, by the way.
essentially
Like,
was
we just,
not an objection raised
like-
regarding the proposal and the filing from the state. I had a brief opportunity to look through the record of the inmate communication forms that have been sent during this trial that are on file. I haven't seen anything that references jury instructions.
I'm fluent in typos, don't
I'm
worry.
aware that
I didn't
he
even
has
notice
other
it.
filings, but I could not find anything related to jury instructions and any specific requests that he is making or made during this case. So for the record, I am approving of the verdicts. I am approving of the jury instructions. And once again, before we break for the day, I will make sure to provide the parties with written printouts of both of the documents as they now stand. Then there are a few other issues we need to go through. Attorney Basie, I think you brought these up prior to the break. Maybe it was Attorney Opper, in terms of scheduling and what I would consider other housekeeping issues, but go ahead and remind me once again of the issues you wanted to bring up. I think it was the alternate sequestration, and there might have been a third.
Yes, Your Honor. The question is to the sequestration of the jurors once they are excused for deliberations, and should the timing require that, like overnight stay or something along those lines. We wanted to discuss that. We wanted to discuss what the court intended to do with the three alternates once they have been selected. It would be our request and position that they should remain in a secure location, separate and apart from anyone else, unless and until full deliberations are complete by the 12 selected to decide the case. So that if needed, and in light of the brief COVID history we have on this record, if needed, one of the alternates could slide into a position of one of the 12 who are deliberating, if that became necessary. So we wanted to address that, and then we just wanted to address timing generally for closing arguments, verdict returned by the jury, and then the court's intentions as to the rest of the week, should there be guilty verdicts returned.
Sure. Before I address all of those, are there any of those final type of issues, sir, that you would want the court to address? You have been unmuted, so you can answer that. Mr. Brooks, do you have any of those final type of questions or issues that you want the court to address? You are unmuted. I am.
I just told you, I'm not, since nothing I say even matters at this point, I'm just gonna tell the jury what they need to know. I'm just gonna tell them the truth.
Mr. Brooks, you are aware that your closing arguments have to be based on law and fact, correct?
They gonna be based on whatever I base them on.
Oh my God.
Well, I trust the state will object when appropriate,
Well,
if
It's gonna be
appropriate.
a whole lot of objection then, because I'm gonna tell the truth. You haven't allowed, you just been making all the decisions for me.
Like, honestly,
Even though,
just let him do
I
it.
told
At
you
this point,
repeatedly that I don't
just
understand,
let
you
him
still make
say whatever he wants to say.
decisions based on
Because he's digging
my
his own
behalf
grave.
without my consent.
Like,
Well,
fucking objection. Don't
I'm
waste your
telling you,
energy.
I don't
Just
understand, and you still make a decision determining my life.
oh, you stupid fuck.
Are you telling me, sir, that you will refuse to follow the simple rules of decorum, courtesy,
If it ain't
civility,
no-
the rules of
don't
evidence,
try to
and
come- don't try to come with
rules
no
of
slick
procedure?
words.
This is why I can't watch
Don't
this
try to
case,
come with
y'all.
some slick words and don't put words in my mouth.
Sir, I am not being slick. I'm trying to
You've
preserve the
been
integrity.
slick. You've
Right.
been slick.
I'm gonna mute you, sir, since what you are saying is not productive. It is not courteous. It is disrespectful. I need to go over these. All right, I'm muting
Oh,
him
y'all.
because I need to go over these.
This is
important
why I
issues that
can't
have
do
been
this
raised
one.
by the state. So as far as the alternates, I do think it is important to keep the alternates who in a secure location, even if that means an overnight, unless and until verdicts are reached in this matter, and I will so instruct the clerk of courts to make those arrangements. We have been doing that all along in any event. As far as selecting the alternates, obviously each of our jurors have a number. I intend to have pieces of equal size pieces of paper made, folded up with each of their numbers, put them in the same turnstile bin that we utilized for the selection of preemptory jury strikes by lot, and to simply pull out 3 names. Those will be the alternates, and then or I should say not names, the numbers, and then the numbers that are remaining would be those 12 who will deliberate. And so I'll make sure that that's out here for the appropriate time. As I indicated this morning, all of the jurors were provided with some information regarding sequestration. It is a practice of that I've approved in this case, that the jurors provide us with certain emergency contact information so that we are able to get a hold of families should there be the need. They're given information regarding sequestration, the purpose of it. If I have not made that a part of the record, I will make sure to get a copy of that filed in this case so that both sides know what was provided to the jurors today before they left. And then I'll also make sure that when the 12 are deliberating, that the 3 who are not are taken to a different jury room with a bailiff, and again, kept in a secure location, but separate from the other 12. In the event one would be needed, we would then take up that issue at that time, but I think it's good practice to have them available if that becomes an issue. As far as timing, I'll first address, I have instructed the jurors to be back at 9 a.m. That's because typically we have a few things to finalize in the morning, so we'll start at 8:30 tomorrow morning. It will also give the parties one final opportunity to read through the many, many pages of jury instructions and verdict forms to just make sure there aren't any other issues that jump off the page or that need to be addressed first thing tomorrow morning. But then I do intend to start with instructing the jury. This case will require a very lengthy time of the court reading off the jury instructions. I do believe it will require me to take some regular breaks, probably every 2 hours, until the jury instructions are read, with perhaps a longer break at the lunch hour. And My best guess is that it'll take between 5 and 6 hours to fully instruct the jury. That's based on the 107 pages. Now, some of those pages, though, are after argument. And so that really kind of begs the question is, will the parties get to their closing arguments tomorrow, or will that be done Wednesday morning? I certainly would like to have the parties make
The
their
goal
arguments.
was to have it done Wednesday,
Um,
but the goal initially
I
was
see
for
the
this to be a
instructions
week-long
that we have
trial,
thus
and
far.
clearly that was shot to shit.
I just, it should be done. Okay, thank you. Single side.
I absolutely think. I absolutely think that the jury is going to spend more time
So
filling out the
given-
forms than
So
debating.
the instructions that I read prior to the parties giving their closing arguments finishes on page 73. So given that, I believe that the parties will be able to give their closing arguments tomorrow. It just may be, depending on where that takes us, whether the final instructions are given the following morning. Because that's another 30 pages. I'd like to be able to do it. It just really depends on how late of an evening. I'm not opposed to going late, but letting the jurors go to the hotel and then starting their deliberations in the morning if that's what needs to be done.
Understood, and we'll be ready. I think from our recollection, it took you about 2.5 hours to read the preliminary instructions, which was 69 pages in length. So if that holds, I think, we reasonably could do closings in the afternoon, and it'd probably take you about an hour, hour and a half to read those remaining 30 pages. And we may still be able to wrap up by 4 or 5 o'clock.
They're going to have their closing, and then they're going to have to give them the jury instructions, which is going to take a long time. She just said
contemplating
probably a
maybe
day
putting a
just to
time
give the jury
restriction for
instructions.
both parties.
So,
we had
because the
solid
judge will
15
read to the
days
jury
of
in the courtroom on the
testimony,
record
so
all of the jury
mindful that this
instructions.
is not a 30-minute
She's saying that's
closing.
probably going to take a day, given
Well,
it's over
actually,
100
I tried to
pages.
keep
So
it in
you're going to have
30 to
closing arguments, a whole day of
45
probably just jury
Just,
instructions, and then the jury will
not cursed
deliberate.
to the jury. And to highlight the.
Like jury instructions are going to
Points.
be all day.
Do you think it would be reasonable to give the parties each an hour total? That would reserve whatever's left from your initial for any rebuttal.
Yes.
All right, Mr. Brooks, do you have any position on that? I am unmuting you. I would note he takes the headphones on and off throughout. He doesn't have them on. He's looking at a book.
I wish you would stop saying, look, I'm looking at the Bible. Thank you.
That is a book, though. It is a book.
Just a book.
No disrespect, but it's a book.
Can't disagree with you there, sir.
Yeah. I mean, people actually live like that. Anyway.
You clearly don't, you piece of
Sir,
shit.
I'm contemplating putting an hour time limit on closing arguments.
I ain't doing no closing argument tomorrow.
The
Oh,
closing arguments will most likely be tomorrow.
I'm
Given,
not doing it tomorrow.
then you'll forfeit your right to give
yeah,
one,
then
sir,
you just won't
because
fucking
it's
do
being-
it.
You can't force me not. What type of court is this where you can say you're gonna force somebody not to be able to give a closing argument? How is that lawful
Sir,
law?
if you choose
How
not
is
to
that
give
lawful law?
one,
How is that lawful law?
sir. If
Because
you
you're
choose not
refusing.
to give
Good.
one you're not
Are you
letting me
fucking
finish,
crazy?
and you're mocking
Yes,
me right now,
obviously,
which is
but-
incredibly disrespectful once again.
Okay.
You didn't even let me get my sentence
You
out.
always want to make an incorrect record. Go ahead, make your incorrect record. Go ahead.
I'll mute him once again because clearly he just wants to be disruptive this afternoon. But as we have been talking about over the course of the last, 10, 15 minutes, talking about the timing of everything tomorrow, even though I have 107 pages of jury instructions, the first 73, I think, deal with what is read prior to closing arguments. That means the parties should be prepared to give their closing arguments tomorrow afternoon.
Yes.
I will do my very best with just one mid-morning break to get through all of these, the first part of the instructions. Then the state will give its closing argument. I'm giving the parties 1 hour each. I think that's reasonable under the circumstances. Whatever the state doesn't use in its initial time of closing arguments, it can reserve for rebuttal. But then following the state, we may need to take a break of some sorts, probably before the defendant goes, just for the jury's sake and the party's sake, and we'll need a comfort break.
Comfort
you should
break.
be prepared to go tomorrow afternoon. Then the state, if they have any rebuttal, will get up within that time limit. I will myself, and I'll have my clerk make sure we accurately time that. I will read the final instructions.
There should be agreed upon time limits, right? Like, is it 45 minutes? Is it 2 hours? Whatever it is, they should have agreed upon that.
You know, if it's 7 o'clock at night, I'll probably tell them.
But like, this guy would clearly argue about whether or not the sky was blue.
They
So
will come back and begin deliberations in the morning. That'll be Wednesday morning. But now that I really kind of laid that out and thought about the break I will have for closing arguments with even my 107 pages, we can get this done tomorrow. And so that's my expectation. So, Mr. Brooks, I'll unmute you, but that is the expectation of the court, that closing arguments will be done tomorrow.
You can't rush me to judgment, or you can't crack the law from the bench and tell them.
she is in charge of this courtroom. What do you
Mr.
not
Brooks, I
understand?
actually can, under all of the rules of procedure, it is my job to make sure there's effective and efficient administration of this trial.
So then I should be allowed to, then if that's the case, then I should be allowed to tell the jury what they need to know, which is the truth. That they have the power. They have the power to.
Okay, but what is the truth?
You are
Like,
absolutely not allowed to tell the jury that. There's a jury instruction that I will have ready to go if you even attempt to raise the issue of jury nullification, sir. You have absolutely
oh my
no
God,
right to
you
raise
can't do that.
That is clear under the law.
I can raise what I want to raise.
everyone knows you can't do that. Everyone knows.
So you added in jury instructions at the last minute, then you should have never approved them from the get-go because I never approved them.
I want to know who's giving him this stuff, like sovereign immunity,
Sir, if you understand
jury nullification, the
you
trust
understand jury
thing.
instructions. It's clear to me you've done your homework.
Yeah, like who's giving him this, all the loopholes?
I'm gonna let them know that they can nullify any law they don't agree with, which is my right.
It is not your right to do that.
Say that it's not.
It is not your right to raise jury nullification.
Show me lawful law then. Show
Oh,
me.
All right, I'm gonna mute him once again. He's starting to raise his voice. He's starting to hit his hands on the table. It's very clear to this court that it's going to be a challenge tomorrow during his closing arguments. He does not have an unfettered right to say whatever he wants. Or
he
how
has come up with some pretty
wants.
crazy loopholes.
If
If it's
he,
just him looking up
is going
Google,
to be
not saying
adamant
he didn't
about
just look on Google,
defying
but
the
he's come up with
court's
some pretty
rules, which I
crazy.
will tell him in part what they are today, and I will
Should.
work on that as we break and have a very clear advisement for him tomorrow morning. He may run the risk of being put in the other courtroom because he'll forfeit by his conduct his right to be present here, and I will be able then to exercise the mute function. I have to balance, frankly, the fact that he's in custody, that it takes time for this jury to be excused. They have to walk an entire hallway behind me. I frankly don't want him to look worse than what he's looked, frankly, in front of this court when they haven't been in this courtroom. I need to preserve how he looks to this jury. And I
See,
will
she's
need
being smart here.
a very clear pledge by him that he will follow the rulings that I make as it relates to the
You
closing
absolutely
arguments.
cannot throw out
He
jury
cannot raise jury
nullification. So
nullification.
that's
He cannot
insane.
raise facts that are not part of the record. He cannot raise subject matter jurisdiction. He needs to argue the
For
facts
those of you that don't know,
based upon his
jury
theory,
nullification is something that
based
you're not
upon the
allowed to
evidence
bring
that's
up.
been
But
presented.
essentially, if you are back there deliberating
And those are the
and
bounds.
the jury
If he's
decides
going
after
to-
hashing it out that
I
they think,
can
fuck
only
this.
imagine there may be some objections.
Here's the
by
example I
state.
normally
If
give.
there is an objection, I expect that
If
he will stop.
Someone, I'm going to
and
mute
wait
this because they're
for
just
this
arguing over the same
court
shit.
to
Jury
rule on the
nullification.
objection.
If
I expect that if I
This is how I explain it.
sustain an objection,
If
then he
someone
will
was
honor
charged with
and if
first
he
degree
can't
murder,
pledge to follow these
but you find
very
out that they
simple
killed someone
rules
that
of
they
courtesy
caught
and decorum that are consistent
molesting
with
their
the
child,
rules of procedure and the rules of evidence,
the jury might
then
decide,
he will
did
be in
he
that
kill
other
that
courtroom
person?
for his
Yes.
closing
But
argument,
do we
so that
think
I
it was
can
justified
exercise mute,
whether
frankly, to
we
protect
should
how
or
he
not?
looks to that jury.
And they decide,
Because that
yes,
is the balancing
they
that
can
I am
say,
tasked
fuck
with
all of
tomorrow,
this.
is to ensure
We are
this jury
going
makes
to not find
a
him
determination
guilty,
based
even
upon the
though
evidence
we
and the
know he
law.
committed
You do
a
not have a
homicide,
right to
because
talk
we as
about
a group
sympathy.
have come together and
That's
said, fuck
very
this.
clear in the case
We find
law,
it justified,
whether it's evidence
even
or
though
arguments. The
we,
juries, if you read through the jury instructions,
under all
sir,
the
you
legal
will see
grounds, should
they
not
are
have.
specifically told
So that's a jury
they will not
nullification.
be swayed
The jury
by
decides
sympathy,
they're
by
going to take things into
prejudice,
their own
or
hands
passion.
and play by their
They
own
are not to
rules,
be
and they can
concern themselves
say not
with
guilty
any penalties.
when they
You
absolutely
can't
know someone
argue
is guilty.
penalties. You can't argue jury nullification.
And that's, you're not
You can't
supposed to
argue
tell them
legal
that that's
issues
an
that
option.
aren't
They're
relevant
supposed to come
to
to that
the
conclusion on
elements
their
and
own.
the other law
Like
that's
a-
in these jury instructions. And
You
those
can't,
are
you
the
just can't
very
do that. You
clear
absolutely can't do that.
rules that you will need to follow. And like any other time in this trial, if you don't do that, you will forfeit your right to argue your case to the jury or forfeit your right to be present in this courtroom and appear from the other courtroom. And you are squarely put on notice of that here today, sir. With that, I think I've addressed all of the issues the state has asked me to address. Oh, one other issue, verdict timing. I know we have some time on this. I realize that there are many, many victims who may still be watching the proceedings remotely. There may be news media, in fact, that may want to cover the verdicts, and that this jury will take some time due to the sheer volume of counts in this case. When this court is advised that verdicts have been reached, I'm contemplating between 30 and 60 minutes before bringing everyone back into the courtroom.
She's an absolute
for,
saint. I could not do this shit
The verdicts to be read
with him.
in open court.
Of course he is.
And if parties believe I need to wait longer, then let me know. But I think some of it will depend on is it late at night? Is it during the day? Are we dealing with any kind of traffic issues? I realize Mr. Brooks has family in Milwaukee area that may want to be here as well.
Or not, for their safety.
The outlying areas of Waukesha, you could be as much as 30 minutes away. So that's my initial thought on that. Any statement from the state on that?
Not on that issue directly, sir. I'm sorry, Your Honor.
It's okay.
I apologize.
Any other issues?
Yes, my other issue as to verdicts was seating, if you intended to maintain the designated benches for the reasons you just said.
I would intend to keep the seating as is.
Okay, with the
The
reserve.
entire side behind the state for victims.
Okay, and the other side,
Public.
reserved for the first 5 minutes, or is that open seating over there?
My rule throughout has been 15 minutes. What I would say is any open seating will open the courtroom. It'll still be open the whole time because we're waiting, right? So it has to be. So any seat that's left open within 15 minutes, victims could also sit on the other side.
Okay.
If that's what you're asking me.
Yes.
All right. Mr. Brooks, any further topics by you?
Am I muted?
No, you're unmuted.
Jury nullification occurs when the jurors
You said, but
decide that they're going to have their own justice, and they decide that they're not going to follow
how can you deprive me
the
of my
law.
constitutional
They're
right?
going to do things their own way, so to speak. That's the simple, easy way.
How?
Sir, you can forfeit a number of constitutional rights by
Ah.
misconduct on your part.
Like I said earlier, it's like if you acquit someone for first-degree murder because you think they had the right to
Sir,
kill
I
that
direct
person
your
or it's
attention to
justified.
Chambers versus Mississippi,
I'm not
Rock
gonna
versus
hear none of that.
Arkansas, State
Yeah.
versus Anthony, Illinois
they
versus
reserve their
Allen.
They reserve their right.
The Beneby decision, there's a host of case law, sir.
Did they reserve their right?
All right, sir, you are simply mistaken on that. So I'm muting him once again. He's not giving me any other issues to address. We are in recess.
Oh, I'm sorry, I have a few
Go
other.
ahead.
I'm
You
sorry.
do. I'm sorry, go ahead.
I just wanted the record to reflect that at about 2:04 p.m., your clerk had provided the final version of jury instructions to both the state and to the defense. I watched on video as Deputy Wittig left this courtroom, went over to the other courtroom, handed the final jury instructions to Mr. Brooks, and he immediately turned and dropped them to his left off the side of the
Right,
table.
like I can't handle this
I can't tell from
shit.
the video if that's where the trash can is
I
located or
can't.
not, but I did see that immediate response after he was handed the final jury instructions. Another
Would that include
thing,
the verdicts or just the jury instructions? Okay, it's just the jury instructions, but thank you, because I didn't see that given some of the things I was looking at up here, so I appreciate that.
were all jurors or will all jurors then be told to report with an overnight bake?
That's part of the instructions that
Okay,
they were.
and you're gonna make that available to us?
Yes, I'll get Lauren down here right away, and I'll make sure that before Mr. Brooks is taken back to the cell. I see your arms waving, I'll get you in a second, that he's provided with that as well.
All right.
And
God, can you
And then one final
imagine,
thing is
like,
the timing, and again, I don't
this
mean
is
to
a
be
clown
disrespectful
show.
to Mr. Brooks or anyone involved in this matter, but should there be any guilty verdicts in this case, would you be intending to proceed to sentencing yet this week or at a future time?
You know, that's an interesting question because I don't know how many victims will want to speak. If we have time, I would certainly consider that. I mean, I have this entire week set aside yet.
Victim impact statements.
And I have Monday morning, but I have some other things Monday afternoon, and then I am not available the rest of next week. So it really just depends on the timing.
Oh,
I would
shit.
need to know from both the parties
Oh,
whether
shit.
they anticipate anyone speaking other than the parties themselves. Any family members? I
Yes,
don't think I need a PSI. This is a trial. This is not like a guilty plea, so. Mr. Brooks, I'll get you. I'm unmuting you. Go ahead.
Let's hear
Go
this
ahead. You're
fuckery
muted.
before he starts doing the YMCA
If you all
motions.
make the records to make you look bad, I think we should say for the record that one of the rights I have is to demand that the court places the evidence in unrevealed contract, statute, laws, rules, or information being used against me under the Sixth Amendment. So how come that hasn't been placed in the evidence?
What law are you referring to, sir?
I'm referring to my rights under the Sixth Amendment.
And what case law says you have a right to do exactly what you just said you have a right to do?
The Constitution, Amendment 6.
So that is very general, your statement. It's vague. There's nothing
So you don't know
specific
what-
you have
what
referenced.
You want paragraph 2 or something like that? Is that what you want?
No, that's not what I'm saying, sir. You're making general arguments that aren't based in fact and are overgeneralizations of what the law requires as well.
I accept the value and return for value any documents in this matter. Since, it might be another record of what I'm doing, since it's always a record of what I'm doing.
You're on national TV, bro.
And I also have the right.
Trust
I
me,
also
there's
have the right to ask,
a record.
is this common law or admiralty law? Because judging by the gold eagle on top of the flag, it's some explaining that needs to be done. That is a military symbol. So is this a common law court or admiralty law court?
Mr. Brooks, I'm frankly not going to address these nonsense legal theories of yours. I'm muting you. They have been debunked. They are typical sovereign tactics that have no place in our judicial system. We are in recess. I'll see everyone tomorrow morning at 8:30. I'll just direct the bailiffs to wait until we have the verdict forms to give. And if it takes us longer than 30 minutes, we'll make sure they're delivered to him in his jail today. Thank you, everyone.
thank you.
Y'all, this shit, I can't. Like, this is why I've not covered this case, because I can't listen to the fuckery 24/7. Like, I can't do it. He's making a mockery of the whole thing, and I just can't. I can't. This poor judge, the poor jury, he's convicted himself at this point. And y'all know that he's absolutely going to say what he's not supposed to say during his closing arguments. And someone on TikTok just said they found a podcast defending him. Dear Lord, denounce baby Jesus, Buddha, Egyptian gods, and Tom Cruise. Full stop. Can't. No, ma'am. No, cannot. I mean, there is no justification. There's not even one that he could attempt. You plowed over people. This case. Any last minute questions? Because it's time for me to have a little snacky and regroup from this fuckery. Because, like, holy shit. It's unbelievable. I guess I can go live tomorrow for this fuckery for you guys. Yes. So I will, we will reconvene on this tomorrow. So, yeah. Oh, Lord bless. Yeah. I will go live again tomorrow so that we can discuss this and all of its fuckery and gain 5 pounds stress eating, because that's the only way that you can listen to this shit. That or day drinking. It's just unfucking believable. So if you're on YouTube, I'm going to go ahead and end it here and we will reconvene tomorrow. So I love you guys and I will see you guys for Fuckery City tomorrow.